Gary Tabakman here, Houston criminal defense attorney. I want to talk to you today about how to beat your case through a grand jury proceeding before it ever moves forward through the court process. So, what is a grand jury? In Texas, every single felony case has to be indicted through a criminal grand jury. The grand jury is put together by specific district courts. The district court judges have a selection process similar to what occurs within the context of a trial, where a jury panel veneer comes in and individuals are questioned to see if they may serve as good potential grand jurors for a certain period of time. Depending on the county, that will be a different amount of time for each county. There's 12 jurors made up of 4 alternates in a grand jury proceeding. These individuals are tasked with the necessity of reviewing evidence, being presented evidence to, and committing to understanding whether or not there is enough probable cause that exists for a case to move forward. Now, as you may already know, and as I've previously discussed in other videos, there are different burdens of proof. So probable cause is a lower burden of proof than beyond a reasonable doubt, which is the burden of proof that has to be utilized in a criminal law trial. So it doesn't take anywhere near as much to be able to have a case move forward or for grand jurors to find that enough probable cause exists. Why is this significant? Well, in Texas, you have the advantage as a defense attorney to utilize the grand jury process and to present packets on behalf of your client. You can actually have your client be present within the grand jury, and you may have your client testify at grand jury. In very, very rare circumstances, I've used that as an advantage to my client's position and my client's case. It all depends on the individual that you're representing, how that individual presents themselves, whether or not it's something you believe may be to an advantage. It also is highly dependent on the type of case that you're dealing with. Some cases are much more open to potential grand jury testimony from a client. Some grand jurors are much more keenly intent on listening to what your client has to say in certain types of cases as well. So there's a difference between a violent case versus a white-collar case, for example. So you want to make sure that you can communicate with an attorney that has experienced all types of different cases and many different types of grand jury proceedings to know whether or not you have a situation where you might be able to present yourself in such a way to where you can avoid an indictment and avoid probable cause in your case. The most important thing that you need to understand is that all grand jury proceedings are secret. So that secrecy stays within the confines of the 4 walls that the grand jurors sit in. Typically, the way that it works is a prosecutor comes in, presents evidence. It could present documents, photographs, video evidence, witnesses. Grand juries also have their own authority and power to be able to issue subpoenas for certain things. The rules of evidence are very relaxed in those settings, so there's no hearsay. Even sometimes illegally obtained evidence can be considered in grand jury proceedings to see if probable cause exists. So defense attorneys cannot go inside, and I cannot be inside a room if you choose to testify. But what you could do is you could come out and talk to your attorney and let the attorney know that, hey, I'm being asked a particular question, like, how do I answer this? Should I plead the Fifth Amendment, for example? Should I not answer and just plead the Fifth? So that is something that you need to communicate with your attorney about to see if that is a possibility for you and if you can utilize that as an advantage for yourself. Now, what happens in the context of a grand jury packet? So this is primarily the reason why I wanted to do this video, so you have a good understanding of how you can ultimately beat a grand jury proceeding for it to go from a true bill to a no bill. And what I mean by that is there's 2 things that happen at the end. One is either a true bill, which means a true bill of indictment, or a no bill, meaning that the jury has not come up with a consensus or not enough jurors have voted for probable cause to move forward, which requires 9 jurors to vote for an indictment to move forward. The grand jury packet can consist of a lot of different things, and again, it's highly case dependent. I have had grand jury packets that have been well over 50 pages because of the complexity of the case or the complexity of the allegation. That grand jury packet could have consisted of a very detailed oriented understanding of not only the background of the case, what happened in the investigation, what probable cause is needed in order to be able to indict that particular case and why not enough probable cause exists in that particular case. It could have been a separate investigation that your defense attorney had conducted on the side outside of the law enforcement investigation that was already made. It could involve character evidence and character background evidence of who your client is. And that character evidence could be dozens and dozens of character letters from individuals in the community, from family members, from employers, teachers, whoever it may be that can write something on your behalf that can portray who you are, and people that know you best and can portray who you are best to a grand jury in order for them to see that there is a very good chance that this individual is being forthright and honest about their circumstance, and it's more likely than not that they did not commit the crime that they're being alleged of, or at the very least, there might not be enough probable cause here. We need to put this one to the side. In that same realm, you can present other things that may have occurred in a space and time within a proceeding. So I've previously done a video on how criminal law and family law intersect together. You could click on the link above here in order to be able to watch that video. So for example, in a family law context, where you may have had a family court proceeding with a lot of filings, a lot of evidence, a lot of things that have occurred, or testimony that has been given, you can use portions of that type of case and use it in a grand jury context. So I have attached court transcripts before, evidence of text messages, videos, other things that have already existed well prior to a grand jury proceeding, things that law enforcement may have never gotten or the DA's office may have never gotten, put together a very comprehensive document that is compelling and that provides for a story that the grand jury will otherwise not hear. And so the question is, well, how do I get this packet together? How much time do I have? What do I need to do in order to be able to piece all of this? Well, it's important for you to understand that hiring a good criminal defense lawyer right away gets your foot in the door to be able to have your lawyer ask for the prosecutor to stop the grand jury proceeding from moving forward in order to give you the time to prepare a packet and to prepare information, or for your lawyer to investigate the case, or for your lawyer to get the discovery in your criminal law case so that you can use that to your advantage in presenting a packet to a grand jury. Most people don't know this. Most people don't understand this. A lot of lawyers that I know have never presented a single packet to a grand jury. That is not a very well strategized understanding of criminal law if a lawyer doesn't do that. And so it's important that you connect with an attorney that can help you navigate that process, explain what this process looks like, explain to you why it's advantageous, and gets you moving in that direction as quickly as possible. Your timing of case being filed and going through with an indictment is sometimes very short, and so you have a short time frame in order to be able to request to present your case. So in summary, the things that we need to know is that these proceedings are secretive. They could be used to your advantage. It's a potential gateway to avoiding a probable cause indictment in your case, and it could give you the leverage that you need in other potential proceedings. If you want a free consultation with me, click on the link below, and I'll see you in the next video.